1.2 billion euros. That's the biggest privacy fine in the history of the internet, and the company that got hit is one you probably opened this morning. No hacker in sight. No firewall went down. They just broke a rule about where people's data was allowed to live. Back in May of 2023, Ireland's data regulator handed Meta that bill for shipping European user data over to American servers the wrong way. But there's a much smaller number hiding inside this whole domain. One that quietly decides who pays and who walks away clean. Stay with me, because it's a clock, not a checkbox. This is the driest, most underrated corner of Security Plus. Domain 5.4 and 5.5, compliance, privacy, and audits. It reads like paperwork. It's actually where the biggest numbers on the entire exam live, and where a passing score hides in plain sight.
Hey everyone, Liam here, and I'll be honest, this is the domain I used to skip. My read was, it's just dry acronyms with no payoff. Then it clicked. Compliance just means proving you actually follow the rules you claim to follow. The piece the exam really tests is who you prove it to. Two audiences, and they're nothing alike. Internal reporting goes up to your own leadership and board, so the people running the place see the gaps first. External reporting goes outward, to a regulator or a customer who holds power over you.
This is Tiffany, and before we go further, the version going around online says compliance equals security. That one's busted. You can be 100% compliant on paper and still get breached tomorrow. And you can be genuinely secure and still flunk an audit over missing paperwork.
Wait, so you can pass the audit and still be the breach?
All the time. It's the floor, not the ceiling. The minimum you can prove, not the most you can do.
All right, Caroline here. If you want compliance to stop feeling abstract, follow the money on the punishment. 4 consequences the exam wants you to name cold, and they get worse as you go down the list. Fines you already saw with Meta. Then sanctions, which can lock you out of a whole market. Then reputational damage, the slow bleed of customers who quietly stop trusting you. But the quiet killer sits at the very end, losing the actual license you need to operate at all. A fine is a number you can survive. Losing your license is the company just ending.
That last one barely gets talked about, and it's the scariest thing on the list.
It's the sleeper answer. A bank loses its charter. A hospital loses accreditation. A clinic loses the right to bill. So when a scenario asks for the worst consequence, don't reflexively grab the fine. Ask what kind of business is in the story.
So if compliance is something you have to prove, how do you keep proving it day after day? That's the monitoring side, right?
It comes down to 2 words the exam always pairs together. Due diligence is the ongoing homework, continually checking that your vendors and systems still meet the standard. Attestation is the formal sign-off, where someone puts their name on the line and swears in writing that it's true. The order is a quiet favorite of theirs. Due diligence comes first, the checking. Attestation comes after, the claim built on that checking. You can't honestly sign off on something you never actually verified.
So do the homework, then sign for it. Got it, Grace.
Now let me put the one rule on the board that catches the most people, because it really is a clock. When a breach hits a European person's data, you don't get to investigate quietly for a month and then decide whether to mention it. There's a hard deadline, and it's shorter than you think. 72 hours. That's Article 33 of the General Data Protection Regulation. 3 things to anchor and watch them draw in. The window is 72 hours. The clock starts when you become aware, not when the breach happened. And you can report in phases if you don't have every detail yet.
And that middle one is the trap, right? Aware, not occurred.
That's the trap, and I'm not paraphrasing it. Here's the actual text of Article 33 on the regulation site. Read it with me. Without undue delay and, where feasible, not later than 72 hours after having become aware of it. Miss that window, and the failure to report becomes its own separate violation stacked on top of the breach. And that's the company we opened on. That aerial is Meta's headquarters in Menlo Park, California, the business that got handed the €1.2 billion bill. One rule about where data lives: And that's the price tag on getting it wrong.
Honestly, here's the thing I kept getting stuck on when I studied this. If my company gets breached, am I supposed to know all these rules myself, or is that the compliance team's job? Where does my responsibility as the security person even start?
Hold on to that, because the answer runs through everything ahead. Short version, the rules are shared, but the security person is the one who makes them real. Coming up, we settle who actually owns your data, line up the 5 big frameworks, and put the auditors themselves on trial. One quick thing first. If you're studying for this exam, there are free practice quizzes and study guides waiting at certs.professorerica.com, so go drill Domain 5 while it's fresh. Now, the privacy half starts with a deceptively simple question. Whose data is it? Whose data is it anyway? It sounds obvious, and it's the most important question in the whole privacy half of this domain. Because the answer is never just the person the data describes. There are always at least 2 other parties holding it, and the exam lives on whether you can tell them apart.
My read is that privacy law invents a few named roles, hands you a scenario, and asks which role a company is playing. Get the role wrong, and every obligation you attach to it is wrong too. Start with the easy one. A data subject is just the living human the data is about. You, me, a customer, a patient.
Here's what flips people though. Most of the world treats data like something the company owns. Privacy law says no. The person stays in charge of their own information even after they hand it over. Every right we're about to cover belongs to them, not to the business holding the file. Tiffany, you've got the cleanest way to split the 2 business roles. Take it.
Gladly, because this is exactly where everybody fumbles. Controller and processor. The words sound interchangeable, and they are absolutely not the same job. Let me put them side by side. The controller decides the why and the how. It owns the purpose. The processor only acts on the controller's instructions, never on its own. Watch the split fill in. Everything on the left is the controller deciding. Everything on the right is the processor just doing what it's told. Say a small bakery decides to email its 3,000 customers a coupon. The bakery chose to do that and decided why, so the bakery is the controller. The email platform it pays just sends whatever it's told, so the platform is the processor. Same data, 2 very different jobs.
Watch where the blame lands, though. If that email leaks the list, the regulator knocks on the bakery's door first. The bakery picked the purpose and picked the processor, so accountability follows the why, not the wiring. Whoever decided is who answers for it. Now here's the trap the exam loves. A vendor that quietly decides to reuse your customer list for its own marketing just promoted itself. The second it picks its own purpose, it stops being a processor and it becomes a
controller. And it inherits every single duty that comes with the title.
You beat me to it, Tiffany, but exactly. So when a scenario has a vendor going off script with your data, it's testing whether you notice the role just changed underneath you.
Now the rights those roles owe the data subject. The headline for the exam is the right to be forgotten, formerly Article 17, the right to erasure. The person asks, and in defined cases, the controller has to delete them. Its sibling is retention. You don't get to keep personal data forever just because storage got cheap. Think of it like the milk in your fridge. Retention is the expiration date stamped on the carton. It ages out on its own. The right to be forgotten is the customer reaching in and tossing it early. Same goal, 2 different mechanisms. But to honor either one, you first have to know what you're actually holding. That's your data inventory, a living map of every place personal data sits. You can't delete on request, and you can't age data out if you never knew you had it in the first place.
Wait, one thing that always bugged me. If a customer invokes the right to be forgotten, does the controller really have to delete absolutely everything, no exceptions? That can't be right.
Good instinct, and no. Erasure has limits. If a law requires you to keep certain records, say tax filings or fraud history, that legal duty overrides the request. The right is strong. It isn't absolute. When 2 rules collide, The one that says you must keep it usually wins.
So retention is the timer, erasure is the early delete, and the law is the override sitting on top of both. All three point at the same idea. The person is in charge of their own data.
And privacy isn't only a security topic, it's a legal one. That building is the European Commission in Brussels, the institution at the centre of the Union that gave us the whole regulation. Mishandle personal data, and you're not just filing a security report. You can be facing lawsuits, regulators, and contract penalties all at once. That's why the objective literally uses the phrase legal implications, and it stretches across local, regional, national, and global lines. One cloud app can owe duties in a dozen countries at once. The security incident is only the first domino to fall.
One more that floats around. People say if you anonymize the data, none of this applies, so just strip the names off it. Half true at best. If a clever person can re-identify someone from what's left, it's still personal data, and every rule we just covered snaps right back on.
Which is the whole theme of this domain, honestly. The label you slap on data doesn't change what it actually is. Regulators look at substance, not what you called it in a spreadsheet.
So the roles decide who owes what. Next comes the rulebooks themselves, because it's not one privacy law out there. It's 5 big ones, and the exam will hand you a scenario and dare you to match it to the right master. One thing before the next part, and then we move right on. If any of this is clicking, tap that like, hit subscribe, and ring the bell for the next one. It takes a second, it costs nothing, and it helps more than you would think.
Five acronyms, and the exam hands you a scenario and asks which one applies. The fast way to win is to ask 2 questions of each. Who does it protect, and who enforces it? Because the trap answer is always the framework that guards the wrong kind of data. Line them up. GDPR protects the personal data of people in the European Union, and it carries the heaviest fines on earth. If a scenario so much as mentions an EU citizen or resident, GDPR is on the table.
The one that surprises everyone is next, because it isn't even a law. PCI-DSS protects payment card data, and it's run by the card brands themselves, not by a government. It's the most hands-on of the bunch, an actual checklist, 12 requirements grouped under 6 control objectives. Keep this current, because the exam does. In 2026, every assessment runs against version 4.0.1, and it kept all 12 requirements. Same 12, just tightened up.
Step back for a second on what all 5 are really fighting over. Rows and rows of this. Servers full of other people's lives, their health, their money, their identities. Every framework we're naming is just a different rulebook for guarding a different shelf in that same warehouse. And the exam is really asking which rulebook covers which shelf. Then the 2 American workhorses. HIPAA guards health information, so any hospital or clinic scenario points there. Sarbanes-Oxley guards the integrity of financial reporting at public companies. It exists because executives once cooked the books, so it forces controls over the numbers. Both of those are United States federal law, written right there. When a scenario says public company and financial records, think Sarbanes-Oxley. When it says patient health data, think HIPAA. Same government, 2 different lanes.
Here's a neat callback to last scene. HIPAA has the exact same 2-role split we just learned. The hospital is the covered entity, the cloud vendor handling the records is the business associate, its controller and processor wearing scrubs.
Then the newest face, CCPA, California's Consumer Privacy Act. Think of it as GDPR's American cousin, narrower in scope, but built on the same idea. The consumer gets real rights over their own data. That one isn't federal, it's state. That's the California state capitol in Sacramento, where a single state wrote its own privacy law when Washington wouldn't. One state, big enough to move the whole country with it.
Quick myth check, because people say PCI is optional if you're small. Half true. No government fines you, that part is real. But let me sort all 5 onto the board so you can match them on site. Match the data to the master. GDPR covers privacy. PCI covers cards. HIPAA covers health under United States law. Sarbanes-Oxley is United States law for the books. And CCPA is California privacy. Watch them sort into the grid. But here's the other half of that myth. The card brands can pull your ability to accept cards entirely, which for a real business is the whole game. So PCI absolutely has teeth. They're just contractual teeth, not legal ones.
Caroline, give them the one-line version to walk out with.
EU people, GDPR, card numbers, PCI, health data, HIPAA, public company books, Sarbanes-Oxley, Californians, CCPA. Match the data to the master and the scenario answers itself.
Definitions are one thing. Living inside these rulebooks when they overlap is another thing entirely. I've got someone who knows global privacy law inside out on the line for exactly this. Let me bring her in.
Happy to join. The single biggest thing exam takers miss is jurisdiction. People assume these frameworks sit in tidy, separate boxes.
And they don't stay in their boxes?
Never. One hospital taking a card payment from a European patient can be standing inside HIPAA, PCI, and GDPR in the very same second.
Wait, 3 rulebooks on one transaction. That sounds paralyzing.
It feels that way, but the move is simple. You don't hunt for the one right framework. You ask what data is moving, who it belongs to, and where those people are.
So more than one rule can apply at once.
Exactly, and the exam rewards whoever sees that, then picks the one the question is actually testing. That overlap lens fixes half the practice questions people miss. Happy to help. Thanks for having me on.
Thanks, Harlow. So we know the rules and who they protect, which leaves the obvious next question. Who checks that you're actually following them? Here's a fork worth a real argument, and it shows up on the exam as audit types. When you need to prove your security to a customer, who should do the checking? Your own team or an outsider? It sounds procedural. It actually decides whether anyone believes the result at all. Caroline is convinced the only assurance worth anything comes from outside the building. Tiffany thinks a strong in-house program catches more, and catches it sooner. I'll referee, and we land on a sourced answer. Caroline, you go first.
Fine. An internal audit has one fatal flaw. The people doing the checking report to the people who did the work. It's your own staff reviewing your own controls, and when your boss signs your bonus, your audit of your boss's project has an asterisk on it, whether you like it or not. Useful, sure. Independent, never.
See, the version that says internal audit is just theater? Busted. Internal teams know where the bodies are buried. They run all year, not for 2 weeks in the spring, and they catch the small stuff an outside firm parachuting in for a fortnight never even sees. Continuous beats occasional.
Hold on, Tiffany. If they're that good,
Go ahead, hit me.
if the internal team is so good, why does every serious customer still demand an outside report before they'll sign anything?
Because that's the one thing internal can never give them. Trust they can put in a contract. An external audit is an independent third party with its professional license on the line. And there are 2 outside flavors the exam pulls apart. External regulatory is when an examiner shows up because a law requires it, no invitation needed. An independent third-party assessment is one you hire yourself to reassure a customer. Different trigger, same outside eyes, and their signature carries weight yours simply can't.
I'll concede the signature matters, I will. But an outside report is a single snapshot, and attackers don't work on the auditor's calendar, so I'm not folding here. The honest answer is both, and the exam actually agrees with that.
So even you land on both, and that snapshot point is exactly where this turns into a real exam answer. The most assurance comes from an independent third party, but how they report splits into 2 types people constantly mix up. The framework is SOC 2. Type 1 asks one question: are the controls designed right today at a single point in time? It's a photograph.
And Type 2 is the one customers actually want because it follows the controls over time. It tests whether they truly operated day after day across a period, usually 3 to 12 months. Type 1 is a photo. Type 2 is the security footage.
So Type 1 says the lock looks great in the catalog. Type 2 says we watched that door for 6 months and it never once got propped open. Guess which one a serious buyer trusts?
And don't confuse SOC 2 with SOC 1, because the exam dangles both. SOC 1 is controls over financial reporting, the accountant's report. SOC 2 is security and the related trust criteria. Either way, the independent firm signing its name is attestation in action, and that signature is the whole product. The customer's own right to audit sits on the same shelf. It gets written straight into the contract, precisely so an outsider is allowed to come look, because the entire point is proof from someone who doesn't collect a paycheck from you.
So here's the verdict, and it's straight from the AICPA framework that actually defines SOC 2. Independence wins for assurance you can hand to a customer, and Type 2 beats Type 1 because it proves the controls ran over time, not just on inspection day.
Fine. Day to day, I still trust my in-house team more. But if an outsider doesn't sign it, the customer won't. And that's the part sitting on the exam.
And that's the honest landing, both in order. Internal audit for continuous coverage, external regulatory when a law demands it, and an independent SOC 2 Type 2 when a customer needs proof they can trust. Each one answers a different question. Now, we keep saying a failure has a price. Let's actually go count it. Let's make the consequence column from Scene 1 concrete, because nothing teaches due diligence like a price tag. We opened this episode on a fine. We'll close it on a settlement. Same lesson, different continent.
This is the breach the exam quietly leans on, because it ties the whole domain together. A patch, an audit, a privacy failure, and a consequence, all in one story. If you remember one case from this entire domain, make it this one.
In 2017, Equifax left one web server unpatched for a known flaw, and attackers walked off with the records of about 147 million people. That's roughly half the adults in the country exposed because somebody skipped a patch a scanner had already flagged. The fix had been available for months.
That's their headquarters on Peachtree Street in Atlanta, a company whose entire business is guarding your financial identity. One missed update, and it became the textbook failed audit story.
$500 million for one skipped patch. Show them how that number gets built.
In July of 2019, the settlement landed, and it stacks up the way a real consequence does, in layers. Let me lay the receipt out and walk it line by line. $300 million set aside just to monitor and reimburse the victims. Add $175 million owed to the states. Then a $100 million penalty to the Consumer Protection Bureau. Watch it total up. Add it up, and the floor is at least $575 million, and the agreement let it climb towards $700 million for one missed patch.
Here's the detail that turns a sad story into an exam lesson. Equifax had been warned. A scanner flagged that exact flaw, and a patch already existed. This wasn't an unknown threat, it was a known one that fell through the cracks of their own process. That gap between knowing and doing is where the $500 million live.
And that's what due diligence really is, straight from Scene 1. Not a once-a-year audit, it's somebody actually sitting down and checking that the patch got applied everywhere it was supposed to. Boring, repetitive, and the single cheapest thing on this whole list.
That's only the American number, though. The GDPR ceiling is scarier, because it scales with you. Up to 4% of your global annual revenue. Not profit, revenue. For a giant, 4% of revenue is the billion-euro range we opened the whole episode on.
PCI consequence is a different kind of fatal, the one from the framework scene. You don't get fined, you get cut off, lose your merchant status, and you simply cannot accept cards anymore. For an online store, that's not a penalty, that's the lights going out.
Think about what that actually feels like on the other end. A small business owner at the kitchen table staring at a number they can't pay and a checkout button that just stopped working. That's the consequence the receipt never shows. The stress, the sleepless nights, the customers who never come back.
And don't forget the consequence that never shows up on any receipt. Reputation. Equifax paid the settlement, but years later people still flinch at the name. That trust doesn't come back at any price, and no auditor can hand it back to you. The fine has a number and an end date. The reputational hit just quietly follows you into every future deal, every future audit, every future customer who searches your name first.
So loop it all the way back to scene 1. Fines, sanctions, reputational damage, lost license. We've now put a real face on every single one of them. They stopped being vocabulary words about 10 minutes ago.
And for the exam itself, here's the strategy this whole episode hands you. When a question asks for the worst consequence, don't just grab the fine. Read what kind of organization it is. A merchant losing card access or a hospital losing accreditation can outrank any dollar figure on the page. The fine is the obvious answer, so the exam loves to hide a worse one right beside it, and the worse one depends on who's in the story.
Caroline, bring it home for us.
If you forget every number in this episode, keep just one idea. Every figure we stacked up dwarfs what compliance would have cost. The patch was cheap. The audit was cheap. The consequence was $500 million.
Compliance is cheaper than the consequence. That's the whole of Domain 5 in one sentence, and it's the line I would carry into the exam and into the job. Let's lock the core. Compliance is proving you follow the rules to 2 audiences. The privacy rules decide who owes what. Controller decides, processor acts. And when it fails, the price is real money, real reputation, sometimes the license itself.
Your win tonight is the cheapest insurance there is. Pick one system you own and ask, could I prove it's compliant if an auditor walked in tomorrow? That gap is your homework.
Next time, watch which single header in a phishing email gives the whole spoof away. We run a real campaign and bust the myth that smart people never get phished.
Don't lose the trap pairs. Compliance is the floor, never the ceiling. Controller decides, processor acts, and SOC 2 Type 2 beats Type 1 because it proves the controls actually ran.
If this made the driest domain finally click, hit like and subscribe so the whole Security Plus path lands in order, and grab the free practice quizzes at certs.professorerica.com and one to chew on. If you could only have one, would you rather pass your audit or actually be secure? Tell us which you'd pick and why in the comments. Tempo, leverage, initiative. Keep all 3 in mind. See you next time.